In Nevada, employers can sometimes be sued for the wrongful acts of their employees. This occurs in two basic situations. The most common is when the employee is simply doing his or her job and an accident injures someone. This is known as the doctrine of Respondeat Superior, a Latin term that means let the master answer. For example, a cocktail waitress at a Las Vegas casino accidentally spills a drink, and a guest suffers a slip and fall accident on the wet floor and is injured. It is appropriate in this case to let the guest sue the casino or its parent company because serving drink is part of a waitress's job and spilled drinks are a normal and foreseeable risk of the casino business. But let's say the cocktail waitress punches a customer for complaining about bad service. Hitting customers is not part of a server's job. Therefore, in most cases, the casino would not be liable for the customer's injuries. But this brings us to a second situation in which an employer can be held liable for an employee's actions. If the employer itself was negligent in hiring, retaining, or supervising the employer can be held liable for what the employee does. So, let's say our aggressive cocktail waitress had a past conviction for assault and battery, or the casino had received several prior complaints about her abusive behavior, but it ignored them. In that case, the casino may be liable because it knew or should have known that the employee posed a danger to its customers. If you've been injured by an employee, call us and we'll talk about how to get you compensation for your medical bills, lost wages, and pain and suffering.